Thank you. Bye-bye.
Good evening, ladies and gentlemen. This is the March 10th, 2022 meeting of the St. Mary's County Board of Appeals, located in the Commissioners of Conference Room of Commissioners of St. Mary's County Meeting Room of the Chesapeake Building, 41770 Baldridge Street, Leonardtown, Maryland. I'm Chairman Dan Ikniowski with 4 other board members. Having met our minimum requirement for a quorum, we will proceed with the meeting. Public meetings are open to the public. In lieu of in-person attendance, citizens may just listen to the meetings on their phones, but not speak to the board by calling 1-301-579-7236 and then use the access code 963443 followed by the pound sign, or view the meeting remotely on Channel 95 and YouTube. If any non-in-person citizen would like to participate by talking to the board when I open the meeting up to public testimony, please call the following number: 301-475-4200, extension 1234. When you call this number, Ms. Sherry Young, recording secretary, will ask your name, address, and phone number and email. In other words, this will be a virtual meeting and a virtual sign-in sheet. Ms. Young will place you in line on hold after I announce that I'm opening the hearing to public testimony. I will open the meeting up for public testimony after all of the presentations and testimony by the applicants and representatives have been completed. For both in-person or call-in, you will be asked to state your name, address for the record, and I will swear you in. You will have 3 minutes to ask your questions or make your comments directly to the board. Your comments will be recorded and heard by those of us in the Chesapeake Building Zoom participants, Channel 95, and on YouTube. After the public comment portion of the meeting is over, the case will return to the board for any closing comments, members' discussion, and decision. The board members and attorney for the board will now introduce themselves, and I'll begin on my right.
Good evening, Wayne Mazensky.
Ronald Payne.
And again, I'm Dan Ikniowski.
Good evening, Rich Richardson.
Good evening, Guy Bradley.
John Hauser, Assistant County Attorney.
And he is sitting in tonight for the board's attorney. Also in the audience, we have Mr. Bill Hunt, the Director of Land Use and Growth Management, Stacy Clements, Planner 3 with Land Use and Growth Management. And again, we have Mr. Hauser here. He's also the Assistant County Attorney, as he mentioned. And we have the new Director of the Department of Public Works, Jim Gosch, is here tonight. In the media control room is Amy Carter, doing the media production for the night. And in the Savage conference room is Sherry Young, Board of Appeals recording secretary. We'll have 3 public hearings tonight that are scheduled. The first is Cheney Loveville Gravel Mine. The second will be Mars Point Restaurant variance. And the third is the Mattingly property variance. Before we start the hearing, for our viewers at home, you will be able to see the staff and applicant presentation on Channel 95 or YouTube as these presentations are being shown. You can also see the documents that have been submitted for the case by going to Board Docs. Ms. Clements will now demonstrate how to locate and use Board Docs.
Thank you, Chairman. Okay. First, you would like to navigate to stmarysmd.com. That's stmarysmd.com. At the top of the ribbon, on the right-hand side, you will see the Board Docs. Once Board Docs is loaded, you will look for tonight's meeting in the center under Meetings. And today is Thursday, March 10th, 2022, Board of Appeals meeting. And once that is loaded, you would then navigate to the middle of your screen at the bottom, and that will give you the agenda. On the left-hand side, it'll give you all of our items that we will be reviewing tonight. Our public hearings are located under number 4. You can click on a public hearing, and at the right-hand side, you will see all the exhibits that are there for the public hearing. Thank you.
Thank you very much. Also, before we start the hearing, Mr. Bill Hunt, Director of Land Use and Growth Management, has a brief presentation to make to the board.
Thank you, Mr. Ignowski. Bill Hunt, Director of Department of Land Use and Growth Management. I wanted to refresh the board's awareness regarding critical area variances because the letters from the Critical Area Commission on the variance cases tonight are more emphatic in opposition to the requests compared to other recent letters. The 5 critical area variances concluded this year have the wording either, "We do not oppose this variance request," or "In order to grant this various request, ... and then the Critical Area Commission letter goes on to say what the board must find if they're going to grant it. You have received copies of the Critical Area Commission letters for tonight's cases, and Ms. Clements includes them in the PowerPoint presentation that she will show you. There is an interrelationship between the critical area law at the state level and St. Mary's County. This interrelationship is that the critical area law is state imposed, but it is locally enforced. All boards of appeals must presume that the specific development activity for which a variance is requested does not conform with the general purpose and intent of the state critical area law and regulations and the local program. The board must make written findings as to whether the applicant has overcome the presumption based on competent and substantial evidence which is presented by the applicant. For critical area variances, the Board of Appeals is empowered to act in accordance with regulations and standards prescribed by the Critical Area Commission and the Department of Natural Resources representing the state, and the local critical area program, which is conducted primarily by Land Use and Growth Management, the county attorney, and you, the Board of Appeals. The Board of Appeals is empowered to act in accordance with standards prescribed by the legislative branches of government. Legislative branches, plural, because of the interrelationship between the state critical area laws and the county critical area regulations adopted by the commissioners of St. Mary's County. The applicant for a critical area variance is required to provide proof that shows by a preponderance of the evidence that the applicant has satisfied the standards for granting the variance. An applicant seeking a variance has the burden of proof to prove all standards have been met. Almost every variance application will turn on whether, when the zoning ordinance is applied to the property, the regulations will produce a hardship relating to the property. If there is an existing reasonable and significant use of the property, neither a hardship nor an unreasonable restriction caused by the zoning regulations exists, and a variance should not be granted. It is inappropriate for the Board of Appeals to grant a variance because the board feels that a proposed design that requires a critical area variance is superior or more attractive than a design that would be allowed without a variance. If there are other areas of the property where a desired use or structure could be located without the need for a variance, an undue hardship has not been established. Thank you for the time to present that.
Any questions?
No, sir.
No.
No. Thank you, Mr. Hunt. We will now move on to our first case, which is the Cheney Lovell Gravel Mine, CUAP 210026. The applicant requests conditional use approval pursuant to Chapter 25 of the Comprehensive Zoning Ordinance for use type 82, extractive industry, within the Rural Preservation District, RPD zone. And I believe we're going to hear from the applicant's attorney first.
Correct. Mr. Wyrow?
Good evening. Thank you for allowing me to attend by mail or by phone. I had an unexpected family issue I need to deal with. The specifics of which I shared with staff, and they can supply it to you. I prefer not to put it on public record for some privacy reasons, but I'd request that very reluctantly that the matter be continued again. And Ms. Young has provided us with 3 dates. Has provided us with 3 dates, and we're available on any of the dates, and would defer to the board on the selection of the date that's convenient to the board and the staff. And that's all I have. Thank you.
Do any of the board members have any questions or concerns about it? The only concern I would have is I'd rather not have a March 31st meeting, because that would be the third meeting of the month. I'd rather move it to the April 21st, if at all possible.
It's April 21st. Good.
Yes, 21st is available.
Okay, if we could have perhaps a motion to continue the meeting to that date and time certain and place being here.
In the matter of CUAP number 21-0026 Loveville Gravel Mine, I'll make a motion that we continue it until April 21st.
At this location,
Yeah, here at 6:30.
and at 6:30 PM.
Yeah.
I have a motion, do I have a second?
Second it?
All in favor?
Aye.
Aye. Okay, then we'll move on to the second case, which is the Marist Point.
Thank you for your.
You're welcome. Which is the Marist Point Restaurant variance. And the Morris Point Restaurant variance application 210159. The applicant is requesting a variance from the Comprehensive Zoning Ordinance, Section 71.8.3, development activity in the 100-foot critical area buffer, and from Section 41.5.3I to exceed the lot coverage limits specified by that section of the ordinance. I guess we'll have a presentation from staff. Will Mr. Hunt be making any comments? Or stand up and raise your hands, both of you, just in case.
In case.
Do you declare and affirm under the penalty of perjury that the testimony, responses, and statements you may give will be the whole truth and nothing but the truth?
I do.
Very good. Continue.
Okay. Now what is it doing? Seem to be having some technical difficulties. There we go. Okay. Morris Point Restaurant. Okay, the first public hearing tonight is the variance application 21-0159, Morris Point Restaurant. They are requesting a variance from Section 71.8.3 of the Comprehensive Zoning Ordinance to disturb the critical area buffer for a 20 by 20 seasonal tent, and a variance from Section 41.5.3.1 to exceed the maximum allowable lot coverage. The legal advertisement was printed on February 18th and 25th of 2022. The certified mailings were sent to adjacent property owners located within 200 feet of the property, and public hearing sign was posted on the property on or before February 23rd, 2022. The owner of the property is Chris Susanna of Viewpoint LLC, and the property consists of 42,602 square feet. It has a restaurant, 2 mobile homes, and sheds. The property is located at 38869 Morris Point Road in Able. It is zoned Rural Commercial Limited. These are the existing conditions as of 2022. Okay. The critical area buffer is set 100 feet from mean high water of tidal waters of the Canoe Creek, or Canoe Neck Creek. The buffer is not expanded for soils or steep slopes. Here is the site plan. Okay, and detail. The applicant is proposing a 400 square foot seasonal tent to be in operational yearly from April until October. And here's the tent, restaurant, the tent they are proposing, and the driveway in, and all the parking. Okay. The property is in the LDA, which is allowed 15% overall lot coverage, or 6,390 square feet for this property. The property currently has the restaurant, the 2 mobile homes, and sheds, totaling 9,888 square feet of existing lot coverage. The property exceeds the allowable lot coverage by 3,497 prior to the request for the seasonal tent. Okay, a buffer mitigation plan will be providing 1,200 square feet of plantings will be required to meet the minimum requirements for permanent disturbance. The buffer management plan will be approved prior to an issuance of a building permit. Would you like to go through the standards now, or would you like to wait until discussion?
Now, this time.
Now? Okay. Okay. That a special special condition or circumstances exist that are peculiar to the land or structures involved, and that the strict enforcement of the critical area provisions of the ordinance would result in unwarranted hardships. Per the letter from the Critical Area Commission dated January 4th, 2022, state law defines unwarranted hardship to mean that without the requested variance, the applicant shall be denied reasonable and significant use of the entire parcel or lot. There appears to be an opportunity to locate the proposed tent entirely outside of the buffer, whereby eliminating the need for a buffer variance. Therefore, there absolutely cannot be an unwarranted hardship for the denial of the request to install the tent within the buffer at the proposed location. B, the strict interpretation of the critical area provisions of this ordinance will deprive the applicant of rights commonly enjoyed by other properties in similar areas within the critical area of St. Mary's County. Per the letter of the Critical Area Commission, the sensitive locations of the proposed tent is not a right commonly enjoyed by other similar properties developed under the county's critical area program. C, the granting of the variance will not confer upon the applicant any special privilege that would be denied by the critical area provisions of this ordinance to other lands or structures within the critical area of St. Mary's County. Per the letter from the Critical Area Commission, that no individual is guaranteed the right to place a structure in the buffer, particularly when there is space available on site to locate this structure entirely outside of the buffer. In addition, the other property owners on lots of this size in the LDA are required to comply with the 15% lot coverage limit, which is already greatly exceeds. D, the variance request is not based upon conditions or circumstances that are a result of the actions of the applicant. The applicant, Viewpoint LLC, has owned the property since 1998 and is proposing the seasonal tent within the buffer and exceeding the lot coverage limits. E, the granting of the variance will not adversely affect water quality or adversely impact fish, wildlife, or plant habitat within the critical area, and that the granting of the variance will be in harmony with the general spirit and intent of the critical area program. Per the letter from the Critical Area Commission, the cumulative impact of allowing an increase in non-conforming lot coverage, even if the tent will be up for 7 months of the year, has a substantial and negative impact on the Chesapeake Bay. Given the lots is waterfront to the Canoe Neck Creek, installing the proposed tent within the buffer and further exceeding the lot coverage limit would adversely impact water quality and fish and wildlife and plant habitat within the critical area. Therefore, such a proposal would not be in harmony with the spirit and intent of the critical area law and the regulations of the St. Mary's County Critical Area Program. And lastly, F, the variance is the minimum necessary to achieve a reasonable use of land or structures. Per the letter from the Critical Area Commission, the applicant currently has reasonable and significant use of the entire lot by use of a restaurant, kitchen, seating area, walkways, parking lot, 2 residential structures, and 2 outbuildings totaling 9,888 square feet. or 22.6%. The allowable lot coverage limit for a lot this size is 6,534 square feet, which is 15%. There appears to be an opportunity to install the tent over the existing lot coverage, whereby eliminating the need for the lot coverage variance altogether. Thank you. Are there any questions?
Do the board members have any questions?
No.
No.
Would there be an applicant going to come up?
Yeah, they'll be next. Any questions of the staff?
No, sir.
I might have a couple of questions. Number one is, do either the state regulations, enabling regulations, or the county zoning ordinance distinguish between temporary and permanent disturbance?
Yes, they do, sir.
And then what is that distinction?
Okay. Give me just one moment. Okay. I don't want it up there, please. Okay. I can give you... Okay. Temporary disturbance means a short-term change in the landscape that occurs as part of a development or redevelopment activity. Temporary disturbance includes the storage of materials that are necessary for the completion of the development or redevelopment activity, construction of a road or other pathway that is necessary for access to the site of the development or redevelopment activity, if the road or the pathway is removed immediately after completion of the development or redevelopment activity, and the area is restored to its previous vegetative condition. Okay, and grading of a development site. If the area is restored to its previous vegetative condition immediate upon completion of the development or redevelopment activity. And then septic tanks are also considered temporary development. Okay, now permanent, oh, she's good, okay. Let's see. I thought I had permanent disturbance. Permanent, temporary. Okay, permanent disturbance means a material and enduring change in topography, landscape, or structures that occur as a part of the development or redevelopment activity, which would include construction or the installation of any material that will result in lot coverage, construction of a deck, and then the exceptions, grading, and the clearing of tree or forest. And that does not include the septic tank. And those are from COMAR. 27.0 or 27.01.09.01B for the buffer terms defined. Okay.
And then the proposed buffer mitigation is proposed based upon the disturbance and a 3-to-1 ratio.
3-to-1 ratio.
Just for
Correct.
the new proposed tent and not for the existing facility that's,
Correct. It's just for the 20 by 20 tent or the 400 square feet.
okay. Anybody else? Okay, we will go on with the applicant's presentation. And Chris, is it you? Anybody else helping you? Whichever you're more comfortable with.
Thank you. Well, I am...
Before you sit down, would you raise your right hand and take the oath? Do you declare and affirm under the penalty of perjury that the testimony, responses, and statements you may give will be the whole truth and nothing but the truth?
I do.
Thank you very much. You may begin.
Thank you for the opportunity. I am Chris Susanen, representing Morris Point, Viewpoint LLC, and the prescribed background in our application. For over 20 years, our restaurant has experienced numerous encounters, including hurricanes, recessions, government shutdowns, power outages, supply and demand constraints, but none so more challenging or devastating than the COVID-19 virus. Throughout the course of the pandemic, which is actually still ongoing, government's endorsed open-air seating for diners with much relaxed regulations. Inasmuch Morris Point acquired a tent for all concerned and compromised individuals to sit, and that's similar to arrangements you've seen throughout local jurisdictions. In August, I was first advised its continued use now requires permitted consent. So I'm arriving here 7 months later following an arduous application process through no less than 7 agencies, 4 hearings, numerous postings and correspondence, as Stacy proposed, and aptly concluding tonight with this attendance. As you can surmise from our supporting letter of intent, Morris Point has the unique hardship of being an entirely water-dependent facility encompassed entirely within the 100-foot buffer. Everything existed there 22 years ago when we took ownership. We haven't asked for anything because we know how difficult it is to make that request. So but it is important to point out this request is not for expansion, but rather for seasonally relocating 8 seats to be in close proximity to the restaurant, all, I feel, within the general spirit of reasonable use for this waterfront property. It is a commercial waterfront property. It's only existed as a restaurant long before the ordinances were in effect. And we understand there's little to no chance of expansion, but again, this is not an expansion. This is strictly just moving 8 seats outside when the weather is fair so we can accommodate people that are afraid to eat with the general public. So we've always strived to maintain high standards of stewardship, preserving plant, fish, and wildlife habitats, which actually remain a large part of the public's attraction to Morris Point. And we understand the need to supplement the buffer in the case of taking 400 square feet of a buffer out. So with that said, I thank you for the privilege of being heard, and I am here to answer any questions.
Board members, Rich?
Yes, sir. 2 questions. The shape of the tent is square, 20 by 20?
Correct.
When it rains, where does the water go? Come off all 4 sides, or have you got a vent set up where it comes down to one spot? Or?
It sheds. It's peaked with 4 sides. It sheds all 4 sides.
So half and half?
4 sides. It's 4 sides.
Okay.
4
Okay.
sides.
Next one, and inside the tent, will there be any semi-permanent items like a stove or a refrigerator?
Negative.
So it'd be just tables and chairs?
Just service to diners.
I can't hear you, sir.
Service to diners would be it. 8 chairs and a waitress service.
Thank you.
Will there be any type of a floor in there?
There can be a temporary floor to stay away from the mud.
Okay. Guy?
To the letter from the commission on stating, the Critical Area Commission stating that you have space to relocate that tent to an area where you wouldn't require variance. What's the answer to that?
This entire process began with the Alcohol Board because there's no sense in getting this privilege or asking for the privilege if we can't serve drinks. So the Alcohol Board was our first stop. And their hearing came out with the issue that it has to be located as closely as possible to the restaurant to have the alcohol service in there. And we have given them a site plan as well that was approved by them, to which the next stop was the Health Department. And that's where the 8 seats came into play. There is no other place to put it on the property that would allow it to be used for what we're here requesting.
So right now you're at a conundrum between different agencies telling you where to put the tent and the Critical Area Commission saying you can't put the tent where other agencies have said that you need to put the tent.
Critical Area's letter indicates such, but they haven't visited the site. They haven't really gotten into the inner issues of this. So it's easy to see on the site plan that there is area outside the critical buffer, but those are two residences there owned, and they're resided by tenants that park there. It would also require walking through the parking lot with alcoholic drinks, which is not going to be allowed by the alcohol board. We'd be back to square zero. We wouldn't even get to square one. Everything has been pretty much approved, the seasonal aspect of the tent, that it can only stay up for 6 months out of the year. It can't even stay more than 6 months. It has to be down in 5 months and 30 days, actually, because it's not a permanent structure.
So back to my point is you have other agencies telling you where that you can put these services, where you can put the tent, and then the critical areas commission is saying you can't put the tent there because you have to put it somewhere else. So it sounds like you are getting told many different things by different people in charge who have the power to deny your request.
Correct. I mean, we've made it over all the other hurdles. Critical area is the only obstacle, which is why we're here today.
Okay.
Any other questions?
Yeah, I've got one. Reading this memo from you, it says, proposed commercial tent seating must be within proximity of the restaurant in order to properly serve patrons in the tent and meet the alcohol beverage board requirements. Okay, what does that mean as far as looking at the one of the maps here and doing it the old-fashioned way, and I might be wrong about that, it looked like it was 2 inches, which would be 60 feet. Is that correct?
The scale?
Yes.
Are you asking about the scale?
Yeah, and yeah. And when they say, what are they really getting at here?
What they're getting at is there's an endangerment to try to move this somewhere else. This all starts with the alcohol board. It's really the only place, well, anything behind that line that's not in the parking area could considerably be used for the tent, but it doesn't fit anywhere but the area that we've placed it over.
But did they come out and take a look at it and say, yeah, this is perfect?
They inspect the property.
Mm-hmm. And once again, how far is it from the...
From the restaurant to the
Yes.
tent is no more than 50 feet.
What's that?
No more than 50 feet.
15?
50,
50. Okay.
50.
All right.
And this drawing's not to scale.
Mm-hmm. All right.
It's reduced.
Okay, I think that was it. Thank you.
I have a question for the attorney, actually. So I'm looking at critical area standards, section 24.4 of the ordinance, and it's saying that no special conditions or circumstances exist that are particular to the land or structure involved in the strict enforcement of the critical area provisions of the ordinance would result in an unwarranted hardship. We have a citizen before us who is facing a hardship because he has multiple boards telling him what to do with this tent, and they are not talking. Who has precedent? Who wins this argument?
Picked a night to have to step into the shoes on this one.
Good. Welcome.
How I would advise the board to look on this one is that it's not so much, I believe, a situation where every agency has to come on board. And if one agency says it's permissible and one agency says it's not, that we have to somehow resolve that conflict by assuming one of these agencies wins or it's, suppose what I'm trying to say is that at the end of the day, if one agency or if there's one regulation that applies that this project would be impermissible under, it's going to be found impermissible, even if there are other regulations and other agencies that would say it's permissible. It only takes failure on one level for this project to fail entirely. So I think how I would answer that question, if that clears up your understanding, Mr. Bradley.
It doesn't, but It's all right. Because it doesn't give us a path forward, because we are here to examine the critical area standards for which he's asking for the variance on. And if we grant that, or if we deny that, depending on which way the board votes, then another agency can come in and go, oh, no, wait, never mind. If he's already got other approvals to this point, and we're looking at the last one, and the last one says no other hardships should, there should not be any other warranted hardships, but sticking to this one creates an unwarranted hardship, it kind of puts us in a bind.
And ultimately, I'd point out two things. The first being that approval of the project is not approval of any variance. The request for that a variance be approved is not an entitlement that anyone has. They have to satisfy the conditions and the standards of the critical area program that we implement. And if they cannot prove an unwarranted hardship under those standards, they are not entitled to a variance. On the other hand, what I would direct the board to is to remember that, as Mr. Hunt pointed out, this is a legislative agency. The decisions of this board will, in the event of a challenge, in the event of a dispute by the Critical Area Commission or any other agency or aggrieved person, this board's findings will be shown some deference so long as there is substantial evidence to support the board's decision. If there is some substantial evidence, if there's a belief that the board can muster enough wherewithal and enough support of their position to decide that an unwarranted hardship exists here, courts should support the board's decision. I think the question, in referring back to the law, as the Critical Area Commission's letter pointed out, is whether an unwarranted hardship does exist when this property, as presently configured, has for many years been able to sustain a commercial business that has stayed in business till now, and perhaps questions ought to be listed of the applicant to build this record of substantial evidence of why, if this variance were denied, that commercial enterprise would no longer be able to continue, and why there would not be able to be a continuing substantial use of this property as there was pre-COVID.
Yeah, I'm looking at the variance request with the Critical Area Commission telling him he can't put something where he wants to, and they say that he has ample space. Other agencies saying you can't put it in this ample space because it doesn't meet our criteria. Health Department, Critical Area Commission, which one weighs heavier? He's going to violate one or two, easily. And now we have a situation where the citizen is wanting to do something with his property, and we have government agencies, state and county, disagreeing with each other. And it's up to us to look at this and go, yay or nay.
If I may?
Yes, sir.
Sometimes when you go through the development process, you have various agencies that you have to get approvals from. Just because you get approval from one agency does not mean that you still have to meet the approval of the other agencies.
Right, but in this,
As the applicant, they've got to balance those things to make sure they meet all of the requirements of all of the agencies.
and then this case before us, if we follow the Critical Area Commission's letter, then it creates an unwarranted hardship because he can't put it anywhere else.
Right.
So that, now we're creating a hardship where he's just trying to do what he has to do to run the business.
Right. In my opinion, I think that the board of the Alcohol Beverage Commission has a requirement, and it's a state law, and they've got to meet it. I think this variance request is allowable. We can vary what the requirements are in the critical areas ordinance as long as we believe they are meet the variance requirements that are in the law. So I think we're a little more flexible with the critical area stuff than we are with the Board of Appeals, Board of Alcohol,
Okay.
All Beverage Commission.
As always, you say something I need to hear. Usually it's shut up, but tonight it's
I never said that. You know, I never said that. Does that help?
Yeah, that does.
Mr. Susan, you say the two trailers that are on site are occupied and they're rentals?
Correct.
The one site plan that you have shows apparently that there are pull-in parking spots there with a grass median between them?
All of the red stripes and the one silhouette, rectangular silhouette are the parking spots.
So that's grass in between there then?
In front of the mobile, yes, it's hardened surface. They're very hard.
Okay. The pier will I be able to dock the 15 by 25 foot boat there?
Excuse me?
Can I dock a 15 by 25 foot boat at your pier?
I didn't understand that.
Is your pier such that a boat can dock there and then go into the restaurant?
Yes.
Okay. And that's about 400 square feet or so, isn't it?
Not in that 400 square feet. There's two piers on the property.
Yeah, so
The boats.
you could park 400 square feet of boat at those locations.
In the proposed tent space?
No, yeah, alongside the pier.
Yes.
So boats can come in, tie up to
Yeah,
the pier and go in?
Enough tying up there for 10 or so boats.
Okay.
None of them stay overnight. It's just temporary. Come and go.
Okay. Can't put a tent, but we can put boats. Any other questions of the board members?
Yes, sir.
In that case, I'll open the meeting to public testimony. Is there anybody in the audience that would like to speak for or against the proposed use here? If we could check the telephones then.
Board of Appeals.
Ms. Young, do we have any callers for the Morris Point restaurant variance?
There are no callers for this case at this time.
Thank you.
Thank you.
In that case, I'll close the meeting to public testimony and open it up to board discussion. Mr. Guy.
I think you guys understand where I'm coming from. Usually on this, I don't like it when government puts down rules and regulations and other agencies within the government make other restrictions, and then you leave the resident with no way out. So they are, and we see this kind of thing quite a bit, where people are asking for something and they're just exasperated because they get to this point and it's like, holy cow, one more hurdle that they have to go through. And then it falls to us to be yay or nay and fall within our guidelines. And we have to look at what else happened outside of this meeting, because this is de novo and this is part of the questioning. And it leads me down a path sometimes where I wonder, the right decision, is it to follow the law strictly like it says, or is it to look and grant the variance like it says, and then later have somebody come back at us, either through the courts or wherever, and go, hey, y'all made the wrong decision, and this is why. So I just don't like the conflict that always ensues with this kind of decision. That's kind of what I'm looking at.
Based on my two questions on where the water goes when it rains, and no semi-permanent fixtures inside like a refrigerator or a stove, 400 square feet sound like a lot, but it's not any further than a square between me and our lawyer. It's a small area.
Yeah.
And I don't see a problem at all with it. I would like to approve it.
Mr. Wazinski?
I understand about COVID and running a business. I used to run a business, but I don't see the unwarranted hardship here. I agree with the Critical Area Commission.
Mr. Payne?
Well, looking at this, I'd have to go along with the Critical Area Commission. There's several reasons why. One of them is And this has nothing to do with Mr. Hunt's speech. It's going to happen. Too many of these things are, well, maybe I should have done this, but I did this. And pretty soon you'll be finding yourself in court with them. I've seen it happen before.
Well, I guess we had two responses to the variance questions or the variance criteria, one from the applicant and then one from the Critical Area Commission. Both of them put arguments together as to why critical area should be upheld. And I don't think if they didn't come down and look at the site and they didn't have some of the information about the liquor board and actually take a look at the site, I look a little less on their opinion than I did what the applicant has said. And I think he has gone through diligently and met all those requirements for what is being done here. I mean, it's not a lot of analysis that has to be done for a 400-foot temporary structure.
Yeah.
Any other questions, comments, concerns?
I'm looking at it like the health department, alcohol board, other agencies have said you can't put it here, you have to put it here. And those governmental agencies have the same weight as the critical area. And it just, one, it's a tent. I mean, are we really getting burdened by a tent? Come on. Two, it's a temporary structure, AKA a tent. And three, he really doesn't have another place to put it. And if the critical area did not take that into consideration, then that's kind of a narrow focus. So.
6 months or 7 months?
It's only allowed to stand 6 months a year
Okay,
by Lugum's
okay. So
decree.
it's all of April, May, June, July, August, and
April through
September.
Yeah, May through October, which is the only time you can use it anyway.
From May to October, okay. Well, let's, if somebody wants to make a motion, let's
Yes, I
include
will.
that.
In the matter of VAAP 21-0159 Morris Point Restaurant, having made a finding that the standards for granting a variance and the objections of Section 24.4 of the St. Mary's County Comprehensive Zoning Ordinance have been met, I move to approve the variance from Section 71.8.3 for the development activity in the 100-foot critical area buffer from Section 41.5.3 to exceed the lot coverage limit to install a tent.
Can I have a second?
Second.
Mr. Medinsky,
Opposed.
oppose?
Yes.
Mr. Payne?
No.
Yes.
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 As you can see, the decision of the board was favorable before you. An order reflecting the board's decision will be prepared by staff and signed by the board within 60 days. A 30-day period follows from that date the order is signed, during which any aggrieved party may appeal the board's decision to the circuit court. The recording secretary will mail you a copy of the order when it has been completed. Good evening and good luck.
Thank you very much. Thank you all.
Okay, our next case this evening will be the Mattingly property, variance application 21-1154. The applicant requests a variance from section 71.8.3 to disturb the critical area buffer to construct additions to existing buildings, adding to existing driveway areas, and add a sidewalk. So with that, excuse me, Stacy,
Okay.
will you going forward?
Yes. Okay, so Okay, the second public hearing tonight is variance application 21-1154, the Mattingly property. They are requesting a variance from section 71.8.3 of the comprehensive zoning ordinance to disturb the critical area buffer to construct proposed additions, which are covered entries, to existing buildings. The applicant is also seeking an after-the-fact variance for unauthorized and pre-existing development activity in the critical area buffer, which occurred prior to the applicant taking ownership of the property. The legal advertisement was printed on January 21st and 28th of 2022 in the Southern Maryland News. Certified mailings were sent to adjacent property owners located within 200 feet of the property, and a public hearing sign was posted on the property on or before January 26, 2022. The owners of the property are Todd and Kelly Mattingly, and the property consists of 3.48 acres. It has a home, a detached garage, a detached garage with an accessory apartment and a recreation building. The property is located at 20718 Clarence Gas Road and Avenue. It is zoned Rural Preservation District. This is the existing conditions as of 2020. Okay, the critical area buffer is set 100 feet from mean high water line of the tidal waters of Back Creek, and the buffer has not been expanded for soils or slopes. We have the site plan here, depicted here, and the detail. The applicants are proposing a to cover two existing stoops that lie within the buffer. A 6x14 cover entry on the house and a 5x8 cover entry on the garage. The applicants are also requesting an after-effect variance to legalize the unauthorized lot coverage placed in the buffer prior to their ownership. This includes a wood deck added to the house, a bathroom addition to the rec building, a porch added to the garage and accessory apartment, and a portion of the garage and accessory apartment. Portions of the parking and driveway and the sidewalks to the house. The applicant is proposing to remove portions of the driveway, an existing fire pit, 2 block picnic tables, and a wood deck from the buffer that was constructed unauthorized by the previous owners.
Can you say that again?
Would you like me to?
Just that part about they're going to remove those?
Yeah, they're going to remove portions of the driveway. Let's see, we've got it up here. Might make it a little bit easier. The portions that are hatched in yellow, those are they are proposing to remove.
Okay.
Okay? They're also proposing to remove this existing deck, these 2 picnic tables, and the fire pit.
Okay.
Okay?
Thank you.
Okay, you're welcome. Okay. Okay, slide 11. Okay, according to COMAR 27.01.12.6 for after-the-fact variance procedures, and COMAR 2701.9 for buffer management, the applicant has agreed to a critical area planting agreement and has posted a bond to be reflecting the 4-to-1 mitigation for after-fact permanent disturbance located in the buffer. Okay. They had to post that in order to be heard tonight. Okay. The standard 3-to-1 mitigation that is required for any new buffer disturbance will be required if the variance is approved tonight, and mitigation will be required prior to our buffer mitigation plan will be required prior to the issuance of a building permit. Okay. Would you like to go over the standards? Yes.
No?
Those are
Oh, no, we're good with that, thank you.
Okay.
Any questions of staff?
No, sir.
No.
No.
Okay. Who will be representing the applicant tonight? For
Good
the
evening,
record.
Mr. Chairman, members of the board. Chris Longmore with Dugan McKissick and Longmore here on behalf of Kelly and Todd Mattingly, the applicants tonight. We do have a PowerPoint.
I'm
that-
getting to it.
pull up.
Thank you, sir. Let's turn mine off. There she is. Okay.
Thank you. Members of the board, I'm very honored to be here tonight with some folks that I've known since I was very, very young. They've been good friends of mine for some time, and they came to me with this issue. And this variance is a little bit unique from any others that I've done. And we'll walk through the slides, and I'll share some of the reasons why we think it is and why we think that they can clearly meet the standards of the variance tonight. So if we go to slide 2. This is just a GIS map of the property, as you can see, and there's a couple other images here that I'll show you. What I'd ask that you look at those, it gives you some layout of the land and the structures that are existing on it. The other thing to note is that the property where the buildings are and at the end of the property where the house is, it's significantly constrained by the critical area buffer, as we'll show on some other slides. It's not just one side of the property, it wraps around, and that's one of the factors that we think you can consider tonight. If we go to the next slide. This is an aerial photo. This is a different version from the GIS map. This is the 2020 photo, giving you the most recent aerial shot. And again, you can see that a significant portion of the property is waterfront, constrained by the buffer. If we go to the next slide. We wanted to give a little history of this request tonight. And again, the applicants, both of which are here tonight, Todd and Kelly Mattingly, are here. And they purchased their property in February of 2020. So they've only owned it about 2 years now. They bought it with all the structures that you see on the overhead photo that I just showed you existing on the property at that time. They wanted to apply to put some covered entryways onto the house and the garage that has the accessory apartment that's on the property. So they did what we want our citizens to do. They came to the county and applied for those requests. When they came in, they discovered for the first time that there were alleged critical area violations on this property through no fault of their own, but through prior owners of the property and actions that they did on the property. So this is an after-the-fact variance request for certain structures or items that exist within the buffer, but it is not an after-the-fact variance request based on any actions of my client. So it's based on the prior owners of the property, and I believe the staff report said that as well. So I don't think that's anywhere in dispute. My clients and their consultant, Laura Clark with Clark Consulting, who's here as well, and available if you have any questions for her, have worked very hard with both the land use staff and in submitting multiple submissions to the Critical Area Commission to try to work through these issues. You have 2 letters in your staff report. One of them we think is kind of an error. The Critical Area Commission didn't understand what we were asking for, but the March 1st, 2022 letter is the one that is the most recent that's quoted in the staff report. I'll touch on that in a few minutes. I view that very differently than the way Mr. Hunt shared in his opening comments what that letter says, and I'll explain that when we get to it. But that's the history of why we're here tonight. My clients wanted to do very modest improvements to their structures. They came in and did it. They were told, hey, through no fault of your own, there's all this mess you got to clean up on your property before you're allowed to put covered entryways on your house. If we go to the next slide. A little further history of the property that we're dealing with, and these are attachments to the staff report, attachment 7 and attachment 8. These are actually some of the critical area site plans as they were done at the time. They're not engineered as the ones you see today, but as they were done at the time. for this property relating to, again, prior owners of the property, not my clients. The one on the left talks about some trees being able to be removed on the property before the garage with the accessory apartment was built. And then to the right of that is the 2013 site plan for permit number 13-1532. That shows the actual application for the garage and the with the accessory apartment on it when it was approved in 2013 by Lugum. And you can see the different signatures and approvals that are on there. This is one of the structures that is at issue in this case. This is one of the structures that my clients have been told violates the critical area buffer. And this is the site plan that approved the construction of it. In the staff report and the Critical Area Commission takes this position that the building was not built where this site plan said it should be and instead crossed over the line slightly, I mean, significantly, but not more than half of the building. And that's where they're saying there was an error made in the prior construction of it, that it was placed in the wrong place. If we go to the next slide. So again, you can see that there were permits done for that. So this is an after-the-fact request, but it's not an after-the-fact based on even the prior owners not attempting to get approvals. They did get a permit, and you can see the two items mentioned here. There are notes in the Lugum files relating to the inspections under that permit that show that a critical area planning agreement was approved in relation to that garage. And one thing that I think is important to note tonight, that the final building inspection was granted by land use on April 21st of 2015 after the property was inspected once the garage was fully constructed. So if we go to the next slide. You can see here, this is an excerpt of those notes, and you can see down at the very bottom of it in 2015, the final building was approved by an inspector of the county. Now, look, it appears now in the site plan that building may be partially in the buffer. And we can go to the next slide and I'll show you that. But obviously when the county inspected it, they did not pick up on it, and certainly how would my clients know that it's in the buffer when they purchased the property, when it had been permitted and approved when it was built. You can see on this is the original portion of the original site plan. It's actually the blow up of the area from the site plan that was easier to see. And you can see that it shows, if you look on the far right of it, that is the existing house on the property that has some claim violations on it. Right in the middle of that square is the garage with accessory apartment. And you can see there is a porch on the front of it that's very important to our request with the sign there. In bold, you can see where the proposed coverways were. There were two on the garage accessory apartment, and there's one that was requested or is requested on the house as well on the rec building to the left there. The critical area buffer you can see in here, but I believe one of the next slides will show it better because we've highlighted it. It is that dash and dotted line. And on this next slide, you can see where that critical area line is. Now, on this slide, I would ask, this isn't really part of the history of it, but I'd ask that you observe how confined this area is by the critical area buffer. And that is one of the standards we need to meet, that the property is constrained in a way that other properties might not be, where essentially almost three sides of it, as you look at this buffer, are constrained by it because of the shape of this particular parcel. Now, on this slide, to give you some sense as to what my clients discovered when they came in and applied for their permits, the areas that are hatched in red, and it's a light red on the slide as it's shown on the screen, are the areas that my clients have been told are in violation of the critical area law and that they need either variances for or to remove. You can see that a significant portion of that garage and accessory apartment building, again, that was permitted and approved, is now being shown as being in the buffer. Just above that to the upper right is a concrete driveway that now appears to be in the buffer that was constructed before my clients purchased the property, and I'll touch on that in a minute as well. And to the left of that, and I may be pronouncing this wrong, is the macadam driveway kind of paved area where a portion, What's that?
McAdam.
Macadam, okay, I knew I'd get it wrong tonight. The Macadam driveway is to the left, and you can see that a portion of that is shaded in red, as well as one small area of that rec building is there. In the bottom right, you can see a fire pit, and you can see 2 picnic areas that were claimed to be violative lot coverage. And then there are the 2 decks that are on the house that, as I understand it from the comments, are not considered impermissible lot coverage, but impermissible disturbance in the critical area, because they are decks that have open slats in them. So those 2 on the house are there. They're both wood decks. So this is what, my clients found out when they walked into land use, that they had all these problems on their property they had no idea existed when they purchased it. Now, if we go to the next slide, this slide is showing you what happened after multiple rounds of communicating with the Critical Area Commission. And this is where I'll touch on that letter that is part of the staff report. I apologize, I don't recall which attachment it is, but it's a March 1st, 2022 letter. It's quoted in the staff report as well when they address the standards. One thing...
Critical Area Commission?
It's from the Critical Area Commission. It's the most recent one that they've issued. There are 2 that are attached to the staff report, and it's the March 1st one, 2022, that they issued after my clients had communicated more with them to address some of their questions. The first letter said that my clients were exceeding the 15% lot coverage on the lot. We don't think that's factually accurate, and we don't think the Critical Area Commission understood what we were asking for. There were more communications after that. That's what prompted this March 1st, 2022 letter. That I believe is the last attachment to the staff report. It got attached on this week because it was a more recent letter. One thing I'll say about this letter that I think is really important to your consideration is, and what I think I disagree with the characterization by Mr. Hunt, is that the Critical Area Commission does not say that you should deny all the variance requests of my client. That it's okay for them to keep some things, like the garage and the accessory apartment that's in the critical area, but they want them to remove other things that are in the critical area. By saying that, they're agreeing that my clients meet an unwarranted hardship standard for at least some of the things they're asking for, that they are entitled to a variance. They also recommend approval of the covered walkways into the buildings, and they say that that would be agreeable to them. Either they meet the standards or they don't. So when you read this letter, even though they oppose some of the relief my clients have asked for, they don't oppose all of it. So they're indicating that a variance is appropriate to some degree on this property. What it appears they tried to do was balance it in their eyes with what was reasonable. This was their proposal, and the areas that we disagree with them on are the areas highlighted in green or blue, depending on how it's coming on your screen. They're asking that my clients remove those portions or those lot coverage on their property, which is a porch that's attached going from the bottom green where there's a rectangle there, a porch that's attached to the garage and accessory apartment. There is the up to the upper right of that is a portion of that concrete driveway, and then to the upper left of that is the Macadam driveway, the portion that they're asking to remove. And you can see it goes right along the critical area line is the portion that they're asking them to remove tonight. So after those rounds, this is how we read their letter of what staff is saying, we need you to remove this lot coverage. The fire pit and the picnic table areas, my clients had no idea there were violations, but they're agreeable to remove those, and we have some other proffers to make tonight. But these are the 3 that raise the concerns for us that we think would deny them a reasonable use of the property as it exists and as it's constrained by the critical area. If we go to the next slide. These are the reasons why for each of those 3 items that we believe it would be an unwarranted hardship. The removal of the concrete portion of the driveway, first of all, will render the existing the access to the existing two-car garage impossible or very, very difficult to access, and probably not to use both bays of it. And the reason for that is that, and we'll show you some photos that show on the ground where those lines are drawn, what it would mean if the concrete drive was taken up. And if you read the critical area letter, what they say is that these items should be removed and that they should be replaced with native plantings. So they're not saying that this could be used as a dirt area or a grass area where cars could go over. They want more plantings put there if these items are removed. It would limit any vehicles going there. It would also limit just folks walking in and having access to the front door of the house. And again, we'll show you that on the ground, because that is a extremely critical concern if their recommendations were accepted. The second recommendation that we have concerns with in their letter is removing the porch from the accessory apartment garage. And hearing the previous applicant, it reminded me of this argument for us, because if you went to the property and saw what it looked like, you would see the damage this would do to that structure, because the roof structures are tied in together. They were all built at once. That is covered by a covered roof. It would be an incredible deconstruction of that structure if you had to take that porch off, as the Critical Area Commission recommends. You might not be able to notice that from just looking at a site plan sitting at a desk, but if you're out there on the site, you can see that, and certainly my clients can provide any details you have on that concern if you have any. It would be a very significant, both cost-wise, and would certainly either damage the structural integrity of that building or take a lot of engineering and construction to make it so that would work. So that's an extreme hardship to my clients. The other portion of the driveway, as we'll show you, that's the area where you can back out of the garage. And again, if they're saying to remove that and put plantings there, there'd be no way to back out unless you're unbelievably precise at doing it. It would cause, certainly a danger or hardship that if you only had that area. The removal of both portions of the driveway would also render two different levels of ground where you're bringing vehicles there, that they're saying you can keep some of it but not all of it. So all of those recommendations we just do not believe are workable and would impose a significant hardship, particularly given the nature of the property and the nature of these requests. And my clients had nothing to do with the problems that they're trying to correct. Now, if we go to the next slide, these are some of the photos of the concrete portion of the driveway to show you what we're talking about. And if you can see that blue piece of tape on the concrete, that's the area that was where the line falls. My clients went out and took the site plan and took the area, and as precise as we could be to show you that. You can see that there would barely be enough room on the remainder of the concrete driveway to get to that far left door, and it'd be very difficult to pull in and back out on the right-hand door there. On the left, it's a little further view out of it. On the right, it's a little closer up. And we think we wanted to show you visually what that would mean if all the concrete to the left of that blue line is what the Critical Area Commission is suggesting should be removed from the property. If we go to the next slide, these are other photos of it just showing it straight on. It's difficult to see the tape. It is there. These do show some angles, again, to show you what a sharp angle would be, and I don't think you could get a vehicle on that left-hand door if that concrete were removed and was required to be planted with native plants, as the Critical Area Commission suggests. If we go to the next slide, this is a little closer up so you can see it even better on the left there of where the tape is to show you where the line is that they're asking to be removed from the property. And on the right, you can see some of the utilities and other items that are immediately off that corner of the garage on the other side of the concrete. So it's not that you could, certainly that wouldn't be advisable to drive on a grassy area like that anyway, but certainly it would be impossible given that there are those items located there. So I think these pictures really demonstrate what the hardship would be if we followed the recommendations to the letter that were in that Critical Area Commission letter. So if we go to the next slide. So here's our proposed solution. You can see the areas highlighted in yellow that my clients are proposing to be removed that would not cause a hardship for them and would remove some of the lot coverage. Again, that was not their fault, but they're willing to try to work and be reasonable in order to have a reasonable use of their property. In the upper right is the portion of the macadam driveway that would still allow them to back out of the garage and have an area to back a car into and then pull back out to leave their property. To the bottom left of the garage and accessory apartment, thank you, Stacy, that's an area of pavement that's there now, it's about a 300 square foot area, as I recall, that would, or it might be 200 square feet, that would be able to be removed from the property, that would take some lot coverage off that is in the critical area buffer. It would restrict the way that they sometimes park for that accessory structure. It'll make it difficult for them to get in and out, but again, in an effort to try to be reasonable, they believe that that would be an area that could be removed that would not cause an unwarranted hardship to them. And then the fire pit and the couple of block picnic table areas, they're willing to remove those. Again, they had no idea those were violations when they bought the property, but they're willing to do that. There was a mention in the staff report of one of the wooden decks being removed. That was part of the back and forth with the Critical Area Commission. I think that's probably where the comments came from. Tonight, we'd ask that not be required to be removed because it is part of the structure of the house. It's already built. And again, my understanding is that's not lot coverage. It wasn't even mentioned in the Critical Area Commission letter when we looked at their footnote and addressing on it. It is disturbance in the critical area, but not lot coverage. So we'd ask that be able to remain. If it would be required to be removed, there'd need to be some type of structure there or platform because you do need that to get out of the house. It's not ground level. So there'd have to be something there anyway. So we think the destruction of moving that, given that it's not pure lot coverage, just doesn't make sense to do it. So this is what my clients are kind of willing to propose to the board would be a reasonable removal of some lot coverage on their part, still meet the standards of a critical area variance, correct problems that they did not create but would not impose the hardship that we think some of the recommendations from the Critical Area Commission would have imposed. Now, if we go to the next slide. As to the driveway, I mentioned that would come up. There's a note in the other permits, there are multiple permits in the file on this property. There's a note that land use had noted that the driveway was not permitted before, and that's why it's part of the variance request today. The prior owners were told that and were told they could get a variance if they wanted to keep it, but nothing ever happened to that back in 2016. That was 4 years before my clients bought the property. The fact that there was a known issue on the property and nobody dealt with it, really, I don't think it's fair for my clients to have to be the one to kind of foot that bill and deal with it when it appears that on multiple levels people knew that and it just wasn't remedied at the time, either by variance or removal. So with them being unaware of it, that's another reason why we think this would be a hardship on them, because that was completely not within their knowledge when they purchased their home. If we go to the next slide. So, our proposed resolution we think is reasonable. It would remove approximately 783 square feet of lot coverage in the buffer. I think that number matches up with the numbers that the Critical Area Commission reviewed in their review. We also wanted to note, and this is part of why we think that there will not be any harm to the environment, the amount of mitigation that is required of my clients is very significant in this case. The reason why is that, again, we're here for an after-the-fact variance. And by requesting an after-the-fact variance, the mitigation actually rises to 7-1 if the board grants the variance according to the Critical Area Commission and according to staff. So for that 1,708 square feet, that's the amount of plantings my clients will need to perform. And you can see the other ones for permanent disturbance and reforestation that are required. So there'll be, and buffer reestablishment. So the total square footage of mitigation that'll be required is 17,491 square feet. Now, in order to appear in front of you tonight, because this is considered an after-the-fact variance, my clients had to deal with a violation that was issued on their property, which they have through the county attorney office. They were also required to post post a bond for the plantings, even though the variance has not been granted yet. That's part of the after-the-fact variance that is usually there to punish the people that did something wrong. In this case, it's punishing innocent people that didn't do anything wrong. And the amount of the bond that they had to post today just to appear here tonight was a bond to cover $10,248 in plantings, and that number will go up if the variances are granted because there'll be additional plantings required as a result of the variance tonight. So my clients will be incurring a significant cost as far as the plantings go, and those plantings are done to mitigate the environmental effects of the lot coverage. So by doing that, they will be mitigating those issues. And again, I wish my clients didn't have to do it, but they're standing here kind of willing to deal within the rules, even though this is not something that they created. So we thought that was worth the board knowing. Now, if you look on the next slide, just to give you a sense of how we calculated that 783 square feet that they're proposing to remove. Those are the square footages there. It's about 320 square feet on the pavement on the south side of the garage, 320 to 300, 360 on the other portion of the driveway, and then the picnic areas and fire pits. So it adds up to 783 square foot as an approximate total. And if we go to the next slide, and this is, again, just in light of the other critical area letter that was submitted discussing the 15% rule and the property only being able to be covered by a maximum of 15%. This chart actually shows that if they were granted the coverings that they asked for and did not remove any of the lot coverage, which they're proposing to remove tonight, they still would have been under the 15% rule. By removing, this is from their site plan, by removing some of that lot coverage, they'll be well under the 15%. So they do not need a variance from that provision. It's only to keep the things that are already there and add the covered entranceways into their structures. So if we go to the next slide. So this again is our proposal and our request, and I think the motion, the sample motion covers both of these. The board would need to grant an after-the-fact variance to allow them to keep any of the structures or items that are shown in red on this exhibit that is to the right of this. They would need a prospective variance or a normal critical area variance for the structures shown on the site plan as requested by them. Those are the three covered entranceways into the two buildings that, again, Critical Area Commission does not oppose. And then, we are proposing that be conditioned upon the removal of the lot coverage highlighted in yellow on this exhibit. And we actually believe that the slide here, if you accept our proposal, could even be an exhibit to the board's order if needed to make it clear what my clients have to remove and what not. I know sometimes once we get to motions, it's hard to know what we're talking about. We tried to give a point of reference for the board in making your motions tonight. And I think if we can go to the next slide, I think that might be it. So that's our presentation to you tonight. I can address the standards, and I'd like to briefly. I don't know if there's going to be any public comment, so I'll reserve on that in case there is any, and then I'll be happy to address those.
Anybody here want to speak for or against, or excuse me, before we do that, do the board members have any questions?
Yes, sir. Yes, sir. Was there a home inspection done when they purchased the house?
I am not certain of that. I can add, they're here. There was one. If you need one of the applicants to testify, they can, but they're indicating that
Did they go through a realtor when they bought it?
Yes, they did.
Okay. It's hard for me to believe that the fire pit and the picnic tables are a violation, but I guess that's what it is. If I understood you correctly, the stoops or the entrance to it would remain?
Yes, so there's stoops or entrances into the buildings that would remain, and my clients that's how it all started. They wanted to put covered entrances into the garage and accessory apartment building. There's two entrances over both of them, and then they wanted to put a covered entranceway into their main home. That's what the Critical Area Commission in their letter does not oppose that. They say if some of the lot coverage is removed, they do not oppose that. On the back side, there are two decks on the main house that, as I understand it, are not lot coverage, and I think the Critical Area Commission agrees because they don't call it lot coverage in their letter. But they're a permanent disturbance of the buffer because they're decks in the buffer. They're slatted so water goes through them, so that's why they're not lot coverage. They're proposing to keep those in lieu of them giving up the other lot coverage that they're proposing. So they're in red on here.
Keep the stoops then. That's
Right, and to
what-
keep those, so to keep everything that's hatched in red here, with the exception of the items that are highlighted in yellow on the screen in front of you is what
Thank
they're
you.
asking.
Thank you.
Mr. Bradley?
No questions.
Are you able to do all the plannings on site?
They do have a plan that they've worked on with Lugum. I think they're all able to be done on site, right? Is that so all of them are able to be done on site. I mean, it's a pretty onerous requirement, but they're able, and I believe that plan has preliminarily been approved by land use. I'll defer to staff, but it needed to be at least approved to a certain degree and bonded in order for us to be here tonight to do the plannings. And that's what my clients have done. If they hadn't have purchased the bond, we wouldn't even be able to talk to you tonight. And that's what they did to follow the rules.
Okay. With what is being proposed to be added, which is the sidewalk and the two covers to the entrances, and then taking away from that square footage, what you've proposed here, what is the actual square footage that'll be disturbed? Or added onto, I guess I should say.
The items that would be added onto, so we're removing the, and I'll give you the numbers. They're actually in the critical area letter, in the footnote 1 of their letter. Actually, it's probably the easiest place. I believe they're in the footnote. And Laura, maybe do you know the exact square footage of the stoops?
For the stoops?
Yes.
Yeah.
If maybe we ought to start getting somebody sworn in.
One of them,
Let's have Laura get sworn in, and we'll be safe. Would you please stand and raise your right hand? Thank you. Do you declare and affirm under the penalty of perjury that the testimony, responses, and statements you may give will be the whole truth and nothing but the truth? Would you state your name, record, and address for the record?
I'm sorry,
State your name and address for the record, please.
Laura Clark, 22245 Timberline Court, Leonardtown, Maryland.
Thank you.
The stoops are...
Please come to the microphone.
We've got, the two stoops are 5 by 8, so it's 40 and 40. And the other one is 6 by 18.
Yeah, and I'm looking at and thank you, Laura, I'm looking at a portion of the original letter, and I believe it would be 93 square feet of new lot coverage over the existing doorways. It would be a total of 148, but there's already stoops there, so it'd be, that's the numbers that we had calculated beforehand. I'm sorry, I couldn't put my finger on it before.
Any other questions? Anybody in the audience would like to speak for or against the matter? Stacy, could we just, in the back row?
There are
Thank you, Mr. Chairman. I'll be very brief because I know I've spoken for a while. The critical area standards, addressing those, the first and really the most critical that's addressed by everybody is that the special conditions or circumstances exist that are peculiar to the land or structure involved, and that strict enforcement of the critical area provisions of this ordinance would result in an unwarranted hardship. Again, the shape and nature of this property significantly restrict it more than other properties because it's essentially a peninsula or almost a peninsula, so that restricts it from multiple sides. But more importantly, the denial of the after-the-fact portion of the request would really deny the use of an existing garage that was permitted and approved to be able to really be able to use in any significant way. And we think that that would impose a significant hardship that applies to the other portion of the driveway. And the removal of that porch, again, would be a significant construction project, again, on a building that was approved and permitted. If we go to the second standard, it's that the strict interpretation of the critical area ordinance will deprive the applicant of rights commonly enjoyed by other properties in similar areas. These are similar structures, and you can look at the home. It's not a huge home. These aren't all the mansions. There's multiple buildings on there, but they're modest, and they existed when my clients bought them. And they bought the property at a price point that had all of these things on it, believing they were properly permitted because they had received permits for all of it but the driveway. So for that reason, we believe that this is not conferring a special privilege on them. That is the third standard. Again, this would deny them access to their garage and impose a hardship on them. And we believe that, therefore, does not confer any special privilege on them. It is not based on conditions or circumstances that are results of the actions by the applicant. That's the fourth standard. As I've shared with you, my clients didn't do anything to cause this. It was the prior owners. And there were other steps along the way where these items could have been noted before my clients bought the property, and they weren't. We're not trying to blame anybody, but certainly I don't think my client should bear the brunt of that when they had no fault. The fifth standard is that the granting of the variance will not adversely affect the water quality and adversely affect fish, wildlife, or plant habitat in the critical area. Again, we share with you the planning agreements that my clients will need to do that will certainly add a significant mitigation to any lot coverage, and really it'll make the property a lot better than when they bought it, because now there's going to be all these plantings fixing what was already on there before they came in and asked for a modest request to add the covered walkways into their homes. And we believe this variance is the minimum necessary to achieve reasonable use of the land or structures. Again, my clients are proposing to give up some lot coverage, and we believe that our proposal is in line with the way the Critical Area Commission looked at it. We have a different balance on it because we're not sure with the information they had that they could appreciate what a hardship the removal of the other items would have been to my clients, simply because they weren't on the ground, and they might not have been able to see that you wouldn't be able to get into the garage, and that how structurally damaging that would be to the one structure that's already on it. And again, the Critical Area Commission recommended that some of the agreed that some of the variances could be granted. We just have a different balance, and we think our proffer is more reasonable to allow my clients reasonable use of their property. So that's our case.
Any other questions from the board members?
I didn't understand the 7-to-1 mitigation. Why was that?
As I understand it, they have to mitigate 4-to-1 because it's after the fact. So they're kind of punished. It's a greater ratio than normal. And then if you grant the variance and they're allowed to keep it, they have to add the normal 3-to-1 to that. So it makes it 7-to-1. Is that? That's directly from the Critical Area Commission comment letter, and staff has included that in the planning agreement. Because of that, it came from the state.
And part of that is actually part of that garage that was approved by the county.
It is.
And they're being punished for that also.
That's correct.
For the whole footprint of the garage, or just that portion in the critical area?
Just the portion in the critical area. It's what's included in the plannings. So it's the portion that was in it. And if you look at the site plan that was presented, it does not look like an engineered site plan. So there's comments in some of the letters that the prior owners violated the permit by building it outside of it. When you don't have an engineered plan showing exactly where the line is on the ground, you can see how that could happen. I mean, that's how it was done back then. And it was even inspected and nobody noticed it there. So I don't think it was an obvious violation to anybody. So, for those reasons, again, my clients are bearing the brunt of it because they now own the property, and that's what the law says to them. But they do have to mitigate 7-to-1 to keep the garage that they bought on their property, the portion of it that's in the critical area. If they wanted to slice it right off there and cut the walls down, they wouldn't have to do 7-to-1. They still have to do 4-to-1, but they wouldn't have to do 7-to-1.
And I don't want anybody to take this question the wrong way. I really don't. But just for my own knowledge, Mr. Hauser, I'm just reading through this as one of my notes. Because it was unauthorized is not an automatic reason for approval. I mean, just because it was unauthorized before.
I believe I'm following your question, Mr. Medinsky, and yes.
Well, I mean, because they didn't know it, we don't have to approve it. I mean,
correct.
You know, when you buy stuff, I'm just stating this. I don't read this the wrong way.
Correct. Just because
Yeah.
Mr. and Mrs. Mattingly are innocent of causing the alleged violation in the first place does not obviate the requirements of the lot to conform to the critical area requirements.
That's a lesson to anybody watching this when you're buying stuff.
And by granting the variance, the property will now conform to the critical area rules because it'll exist with a critical area variance, which is allowed by the rules. So that's what this board can do to remedy that.
Any other questions? Any other questions? Anybody want to do a motion?
No, I'm not ready for a motion yet.
Oh, I'm sorry.
I mean, I'd like to get the consensus, you know, how everybody feels about this. And then I'm thinking we'd have to go with one of the, if we were going to approve it, we'd have to go with one of the applicant's slides. I mean, to me, it would be the only way to approve it. With the after the fact variances and what they were taking off, and
Well, that should be included in the motion.
that's what I'm saying.
Right.
Yeah, that's what I'm getting at.
I'm willing to accept. I think the applicant's done a good job in trying to correct something that's not their fault.
I agree with that.
And I totally agree with that. It's not, these people are not criminals.
No. Well, we don't know that.
Oh,
To
no.
be very plain.
I just don't know the best way to go about it. I mean, we have the motion, but
I mean, if I may suggest, the thought of the slide that's up now was that portion of the site plan may be an appropriate exhibit for your motion. And I think would be that a variance is granted for all lot coverage and permanent disturbance as depicted on that site plan within the buffer, with the exception of the items highlighted in yellow, which it's a condition that the applicants remove those, something to that effect. And that would make it clear to staff when my clients go and do the work, what they had to remove and what they didn't. So the yellow has to be removed. Variances are granted after the fact, and prospective variances are granted for everything else that's depicted on that exhibit. I think would probably be clear enough, because we always want to make sure, and I know staff raises those concerns legitimately, to make sure once the order's in place, it's easy to follow and there won't be any concerns later on.
we don't have that motion, though.
Yeah, we don't. I just see that it was the prior motion that we had there.
I mean, if we could take a few minutes.
Yeah, let's take a 15-minute break and reconvene at 8:30.
Thank you, Mr. Chairman.
Call the meeting back to order. We have been discussing the Mattingly property variance application. We've had testimony from the applicant, staff review, board discussion. Are there any more comments from the board?
No, sir.
No, sir.
No.
Well, I guess one of the things I would like to say is, as far as meeting the variance requirements that are in the ordinance, I think Mr. Longmore gave a great presentation to cover all of those items that are in there. Now, I think I was wondering if we had a motion that somebody would like to make?
I'll make the motion.
Okay.
Second it.
Well, wait a second. Let me make
Always one in every crowd. In the matter of VAAP 21-1154, having made a finding that the standards for granting a variance in the objectives of Section 24.4 of the St. Mary's County Comprehensive Zoning Ordinance have been met, I move to approve the variance request from Section 71.8.3 of the Comprehensive Zoning Ordinance for the after-effect variance for unauthorized and pre-existing development activity in the critical area buffer. And I also move to approve the variance request from Section 71.8.3 of the Comprehensive Zoning Ordinance to disturb the critical area buffer to construct proposed additions, covered entries to existing buildings, upon condition that applicants remove the lot coverage shaded in yellow on the site plan depicted on slide 20 of the applicant's presentation and perform the plantings required by the Critical Area Planting Agreement 21-1154.
We have a motion. Is there a second?
Second.
All in favor?
Aye.
Aye.
Aye?
Aye.
Aye.
Very good. Let me find my proper spot here. An order reflecting the board's decision will be prepared by staff and signed by the board within 60 days. A 30-day period follows from the date the order is signed, during which any aggrieved party may appeal the board's decision to the circuit court. The recording secretary will email you a copy of the order when it has been signed. I want to thank you all for solving the problem or moving in that direction that was created by others. I think you did a good job in doing that, and I'd like to wish you good luck with the project.
Yeah, good luck.
Good luck.
Okay. Next item would be the approval of minutes, but we have no minutes from the past two meetings, and they will be available at the next meeting. Okay. And then we do have orders for 3 properties, and they had errors in the cover that previously that have been corrected. The first one is for the Crowley property, and the applicant had property in Popular Street and Piney Point, and they have requests for a variance in the critical area from 71.8.3 of the St. Mary's County Comprehensive Zoning Ordinance, disturbance in the critical area buffer to just construct a dwelling and a driveway, and that was approved by the board.
I make a motion to sign the order.
Second.
In favor?
Aye.
Aye.
Aye. The next one I have is for AAA pit expansion, and this was the expansion of a gravel pit along St. Andrew's Church Road in the vicinity of Brown Road. And again, that went to public hearing, reviewed the evidence, and I don't believe that was unanimous. Those approving the conditions were me, Mr. Brown, Ms. Delahaye, Mr. Medinsky, and Mr. Richardson. And again, that's got to be corrected. And did you vote for that or against that one? You voted for it. Did somebody vote against it?
I think we all voted for it.
Okay.
I think the vote was unanimous after specifying the conditions on
Okay,
that one. When
okay.
I went back and looked
But
at
then
it.
this has got to be corrected
Mr.
also.
Brown certainly wasn't present. I can make that correction.
I better double check this one. This one's good. Then the third one I have is the Hoe property, and the variance requested was for a variance of 71.8.3 of the county's comprehensive zoning ordinance to serve the critical area wetlands buffer to construct a single-family dwelling, and I think that was approved unanimously. One, two, three, four, five, which is
Make a
correct.
motion, we sign the order.
Second.
All in favor?
Aye.
Aye. Okay,
The business, we got a meeting next week?
we have a meeting next week. And on the agenda for next week's meeting are Passant Close Properties and Smith Creek Marina LLC. Those are the two items that we have.
Yes, sir.
Anything else for the good of the cause? Watch your snow tires. Make sure your snow tires are good for tomorrow night. And if you got any questions, call him.
Make a motion, we adjourn.
Second? All in favor?
Aye.
Aye. Thanks. Meeting adjourned.